Hello, everyone. This will be your lecture in contract law, which is your one of four weeks that will be spent on contract law because it's so important to business, as this is a course in business law. We, as you will see, the beginning of the chapter is called Introduction to Contract Law. I do need to add in a concept that's not in the chapters here in the textbook, which is where contract law starts when you take it in law school. And that is a concept called promissory estoppel, which means, which answers the question, what happens when you make a contract to somebody, a promise to somebody else, and don't keep it, but it is not a contract? So in the textbook and chapters on contract law, we're talking about a formal contract where, for example, one person offers to pay for a good and service and the other person promises to provide the good and service. If you meet the requirements that we're going to talk about here as to a contract formation, then it's an enforceable legal contract. A promissory estoppel happens when somebody makes a promise and then doesn't keep it, and another person suffers harm from the broken promise. And that is very common, and it's a major mistake that I see out in the world. So a lot of people take a business law course or get some sort of very basic idea of contracts and then think that if they don't form a contract, they can make any promise they want and it won't be enforceable against their business. Then other people are harmed by essentially lying about what you're going to do as a business, and then there end up being a lawsuit, and the party that thought that there wasn't a contract, therefore they can't be held responsible, is held responsible. Okay, so that's why it's so important to start with this concept of promissory estoppel, where estoppel is what's called an equitable remedy, which means that a court can find a remedy, but it's not in the law. What we're talking about in the textbook is in the law, that's legal, and then equitable translates to fairness. So promissory estoppel is essentially saying promissory fairness in some words, and one party would be estopped from breaking the promise without paying damages. Okay, so I do want you to become familiar with this concept of promissory estoppel, and I'm going to give you an example. Okay, so imagine that you finish your college education and you do some interviewing and you get a job, a verbal job offer from a company, say out west in Washington. Let's pretend it's Microsoft. And you're very excited to get this offer. And the hiring manager at Microsoft says, we realize that you are in Texas. We really liked the interview that you did and your qualifications. And what we'd like you to do is come to Seattle and start a job with Microsoft. We want you to be there on the 1st of June after you graduate. And your starting salary will be $85,000, say. And we look forward to seeing you then on June 1st. So but you don't have a employment contract. Nothing is signed. And as we'll cover later in the course, employment is employment at will. So that means that you can be fired for almost any reason, any lawful reason at any time, which a typical trick question there is, there's a presidential election going on and you say you support the Democrats, and then everybody who's working there is a Republican, and then your boss calls you in and says, we're firing you because you said that you don't support our political party. Can you do that? And an employment at will state yes. Okay, so then a common point of confusion is amongst hiring managers who aren't trained as lawyers is they'll think then that they can make employment promises and simply cancel them. So then what happens is you finish college here in Texas, you put all your stuff in a U-Haul and you drive all the way to Seattle. You rent an apartment there, which I'm sure is very expensive. You buy some furniture and some new business casual clothes, whatever they wear at Microsoft. You go in to work then on the 1st of June. You go up to the front desk and you say, hi, John Smith should be expecting me. This is my first day of work. The front desk person gets on the phone. John Smith comes out and says, oh, I'm so sorry. I forgot to call you, but we decided not to fill that position and we just didn't let you know. And sorry, but thanks for coming. And the question then is, the first question in your lecture is that a breach of contract? And what would be the result? And the answer is that there is no employment contract and it is employment at will. But as I said at the beginning, there is this concept of promissory estoppel where you made a promise and you are estopped from breaking it as an equitable matter. And if you do break it, you're going to have to pay damages. Okay, so that is the kind of situation where promissory estoppel arises. It means that you made a promise that wasn't a contract, and somebody else justifiably relied on the promise. And here the promise was that you were going to have a job at Microsoft on June 1st, and you should show up there, which you did. And there has to be actual damages, which here the damages would be measured by the cost of moving yourself from Texas to Seattle. I picked Seattle because it's a good distance away, so it's clear that you would have spent thousands of dollars trying to move yourself to Seattle. Plus, if you had another job offer, say with a small accounting firm in Texas, which you turned down because you were so excited to move to get a job with Microsoft, you would also have the damages from not having that other employment that you had turned down. Okay, and as a matter of promissory estoppel, when you break that promise and somebody else suffers harm and relies on the promise, expecting you to keep it, even though it doesn't constitute a contract, you can get damages, but solely for your loss, okay, not extra. So the extra would be if your salary at Microsoft is $85,000 and the job in Texas at an accounting firm was $65,000, you would only get the $65,000 until you got another job, and you would have to try to find another job, and you wouldn't get the difference between the 65 and the 85. Only the damages that you suffered as a result of the promise and not the benefit of the bargain. So in contracts, if you had signed a contract for a year to work for Microsoft and the same facts occurred, then they'd have to pay you the $85,000 salary. That happens a lot. It's most often that when somebody leaves a job, the employer does end up paying something if there's a contract. You'll start having employment contracts when you've been working about 10 years. People get to the point where they won't show up for a job unless there's a guarantee for some period of time. When you are just starting out, as you will be for the next 10 years, you're going to be an employee at will. and anything could happen, right? As you will certainly find out. Okay, so that is the concept of promissory estoppel. Now we were moving on to the formal definition of a contract and how you get to have something more than just a promise, and now to have an actual contract, which means a contract is a legally enforceable promise, where all the elements of the promise are going to be enforceable. The promissory estoppel is sort of a backstop where you don't quite have a contract. And that is an example of an equitable remedy. Okay, so the elements of a contract, you have to memorize these. There are 4. That is an agreement. An agreement is normally an offer and acceptance. Then there has to be consideration. That is, both sides have to give something of value. It can't be only one-sided. The contract has to have a legal purpose. That's very simple, so I guess I can cover that right now. That is, if you make a contract to import a boatload of cocaine into Florida, and the drug cartel doesn't keep their promise, it was a legally drafted contract, you can't sue in court for that because it has to have a lawful objective. Occasionally the police will trick somebody into saying, did somebody steal your drugs? We have them. Come into the police station to pick them up, right? And occasionally somebody goes in to pick them up and then is charged with a crime. Then the 4th element is called capacity. That means legal capacity. So that would mean that the person is of age, of sound mind. Okay, we'll talk about that a little bit more in detail. Okay, so I'm going to talk about a couple of the different details first. The source of contract law is the common law. Remember, the common law is the cases that have arisen in contracts all the way back to England, right? So that group of cases has been organized by professors into something called the Restatement of Contract Law, and it's the second restatement that has been used for my life, so a long time, and so it's called the Restatement Second of Contracts. That is the formal description of the common law of contracts, all the cases that are thought to be relevant. And those are citable in court. So you would cite to the Restatement of Contracts for questions that arise under any of the 4 things that I just talked about. Okay. And there is now another concept that you have to understand, and that is that there was the common law of contracts, which has 1,000 or 10,000 different cases, and they resolved issues however the judge decided at that time, maybe 100 years ago. And that was found not to be convenient for big companies like Walmart or any large consumer company, because the rules were very complicated and they weren't practical. So often the judge would say something like, we're going to split the baby, okay? And that is not what large manufacturers and companies want in the sale of goods. They want practical, clear rules. Accordingly, a new statute of contracts was put forward, a statutory code. So think of the Internal Revenue Code, where you go and look up the tax rules in the code, and to some extent, they're written down there. Okay, so it's more black and white than the common law. If you take my tax course, of course, I will explain that. Even with all the rules, the tax code is gray, and that's why we have accounting courses in tax. However, we needed something like that for the sale of goods. And that became what is known as the Uniform Commercial Code. So that's like the tax code. It's a code that has all the rules written down, which has then been adopted, I believe, in all the states in the United States as the rules. So there, the legislature of the state says, we've got all this common law, but we need more specific rules for the sale of goods. And therefore, we're going to pass this as law. So the Uniform Commercial Code is drafted by professors to provide very clear rules with input from the big companies. And then it's adopted by all the different legislatures. And that provides the contract rules for the sale of tangible goods. Okay, tangible good would be like a car or a can of beans or coats or whatever, computers. Those are all covered by the Uniform Commercial Code, which provides for the sale of goods and only goods. So and only commercial goods, not private stuff. The common law still applies to all other contracts, where a very typical contract that's covered by the common law is a real estate contract. So the sale of a house is not covered by the UCC. That's most often what they're going to test you on is, do you see that there's real property contracts and then goods contracts? But the goods has its definition as I've provided to you, and that means that the rules under the Uniform Commercial Code apply. And they're slightly different, right? So there'll be a couple different situations as we move through the next few weeks on contracts where we will point out the difference. But the most important thing for you to realize is that the Uniform Commercial Code is a set of contract laws put forward in a statute that only covers the sale of goods. Okay. The next critical thing for contracts is to distinguish a bilateral contract from a unilateral contract. So a bilateral, think of a bicycle. A bilateral contract is the vast majority, 99% of contracts. And the idea is that one party promises to do something, like promises to paint your house, and the homeowner promises to pay. That exchange of promises creates promises on both sides, so it's bilateral, two-wheel bilateral bicycle, and that is an enforceable contract. A unilateral contract is happened with Lady Gaga in California, where she had a very desired dog that she lost. It was unclear whether somebody had stolen her dog or not. And what she said was this: if anybody brings back the dog, I will pay you $200,000. Now that is what is the quintessential example of a unilateral contract. And I think somebody did bring it back. I think she got the dog back. So then let's imagine the situation is Lady Gaga has lost her dog. She's distraught. She's got infinite money, essentially. And she figures out a number that is going to cause either whoever stole it or whoever found it or whoever got it from the person that stole it or found it would bring it back, and a number that would be high enough that it's much more than that person could possibly sell it for. And she puts that out as a reward on the internet. And it works. So somebody comes back and says, I have the dog. Okay, here it is. turns the dog back over to Lady Gaga. Question 2 for the lecture is Lady Gaga says, "Oh, that's wonderful. Here's little poo-poo back," and walks into her. I think there were rules on how you had to accept it, so she didn't want to actually come in person or tell you where she lives, but somehow they follow all the rules. And she gets the dog back and just says, "Thank you. No, I'm not going to pay now that I have the dog back because I think that you stole it." Can you do that? And the answer to that question is generally not. So the unilateral contract means that one party made a promise and the other party accepts the offer reflected in the contract by doing the thing. So in this case, that was bringing the dog. And then there's a unilateral contract is formed. So that then becomes a legally enforceable promise that she would have to pay the 200,000. Okay. And that is a little bit different than the example that I started with from promissory estoppel because can anybody think, let's make question 3 in the lecture is this. Why would the showing up at Microsoft for work not work as a unilateral contract obligation? So that you essentially saying, I didn't show up with a dog, but I showed up myself. And the deal was that if I showed up, then I would have a job. Why would that not work? And the answer is that it's employment at will. So if you insisted on, if you said to the boss, but we had a deal here, and you said if I showed up, which is what you wanted, then I would be employed. Because the boss would just say, the hiring manager would just say, okay, it's 9 o'clock, you're on time, you're hired. Okay, it's 9:01, you're fired, right? They don't need a reason. So that wouldn't work there. The unilateral contract has to be fully executed and isn't for example, a year's work or something. Okay, next concept in contracts are express versus implied. This is sort of just understanding what those words mean. An express contract means that the terms are specifically spelled out. So when you buy a cell phone contract, it specifically says how much you are supposed to pay and how much you're supposed to get back. And all the terms are there in a very long document. That's an example of an express contract. An implied contract is something happens where there isn't time to work out all the details, or the parties just don't. That would be, for example, if you have a contractor come to your house to do some kind of work, and you don't specify how much it's going to cost or what they're going to be paid, you'll have then an implied contract. So let's imagine that you have a light fixture that needs to be fixed. The contractor does do it, but you don't say how much it's going to cost or anything. The implication is that you're going to have to pay the going rate. So you never ever want to do that if you're hiring contractors or have somebody work on your car without deciding up front how much it's going to cost, because you are essentially at the mercy of the person to pay. Okay. So in a situation where the example in the textbook is you go to the dentist where to get a tooth pulled and you don't talk about how much it's going to cost. Sometimes people are just embarrassed to talk about fees before the work is performed and then get taken advantage of. Okay, a valid contract has the four elements that we talked about, which is agreement, consideration. We're going to go back to these particular things. Legal capacity and lawful object. That results in a valid contract. And void contract is one, for example, that has an illegal object or never became a contract legally. A voidable contract, so we have void and voidable. So question 4 in the lecture is this. So you have a teenage child. The teenage child stays up all night and watches, let's say a young teenager, like 11, watches TV overnight, and there is a television advertisement for a new, let's pretend it's a drivable car that the kid really wants, right? So it's a Cadillac Escalade, but for a kid, right? So it's small, you get in it, it's got batteries, and the kid watches the infomercial. The kid takes your cell phone and orders the toy for $2,500. And the company taking the order, imagine it's by phone, does not realize that it's a child, or the child orders the item on your phone. This can also happen with children getting an online game that has in-game purchases and on your phone, and then clicking, yes, I want to upgrade my character, right? And then you get a bill for $2,500 from Google Play, right? So those two things are essentially the same. About a month later, you determine on your credit card statement that you have purchased a child-size Cadillac Escalade for $2,500, and it appears at the door. You call the company and say, what happened? And they say, well, so-and-so, you bought this about a month ago. And you say, no, I didn't. And they say, well, we have an audio recording of you buying this. They play the audio recording, and it's clear that it is the child. Do we have there a void contract or a voidable contract? That is the next question for the lecture. And that's going to be probably a voidable contract. That's an example that I like to give of a voidable contract. So if you are, now the company is going to say that you provided the purchasing information to the child, especially if you give them access to your phone and you're talking about a game. If the child steals your credit card to purchase it, even though it's your child, that's going to lead to most likely a voidable contract where you could either say, okay, I understand that the child purchased it and that's not so bad. We kind of wanted a child's Escalade for $2,500 and we're going to keep it. In that case, the contract would go forward. However, you're not required to do so because the child was not of legal age and lacked lawful capacity to make the purchase. So if you do have that situation and call and explain that your child, who is not of legal age, made the purchase, that makes the contract voidable. And that means that you would send back the car and say that there was a contract with the child. The child had entered into a contract but wasn't able to do so, so then it's voidable. And then that means that it can be terminated. There are others. Yeah, it does give the example of purchases by a minor. Unenforceable contracts would be where a contract isn't signed or so there's some other problem with it. Okay, next we come to the concept of the agreement. So there were four elements of the contract. We had offer, and we had agreement, which is offer and acceptance. So under the common law of contracts, in order to have a contract, the offer has to be exactly the same as the acceptance. So, for example, if you go to buy a used car and the used car salesman says, okay, we will sell you this for $12,000, and you say, I accept at 11,000, do you have a contract? The answer is obviously no, because you did not agree. There has to be a meeting of the minds on the price and the car. So if the acceptance is for a different price or different in any respect, this is called the mirror image rule. That's a term that you have to memorize. They have to be exactly the same. Or if there's a mistake, so sometimes a used car salesman will play a trick. They'll say, yeah, you bought a blue Lexus. And you say, no, the car that I was looking at was gray. And then they'll say, but blue, gray, who cares? That's what it was. And of course, it's most likely that they had two, right? And they sold the one that you were looking at, but then they try to substitute in a different one, saying it's very similar. That does not suffice. So it would have to be that particular car in order for the contract to be valid. In addition, if you went to a used car dealer and pointed and said, I want to buy that car up front for $10,000, and the car salesman says, sure. And then they bring around not the car that was on the pedestal out front, but a car that was on the corner out front, right? It's not the car that you agreed on, but you had already signed it all up, right? And that is not a contract because there wasn't a meeting of the minds. It has to be, both parties have to have the same understanding of what they are buying and selling. So any vagueness means that there is not an agreement. Every single term that's specified has to be mutually understood as the same. Okay? Then you have an offer and an acceptance. If you have a situation where the car dealer says, I'll sell you the car for 12, you say no, 11, then the car dealer says, okay, I accept, then you do have a contract at the 11. That 11,000 is technically a counter offer. That's how it would be interpreted. And the counter offer is valid only if the other party accepts. So their silence is not enough. So if either an offer or a counteroffer is left hanging, it does not create a contract unless it's accepted. If you had a situation where the car dealer said 12, you said 11, then you showed up and the car dealer gave you the keys, you'd see that would be a difficult situation. It would probably be 11 because you'd have an acceptance and nothing else was said. Of course, that can never happen because they write up a contract for the sale of a car. But if there wasn't, then you'd have an acceptance by the act of handing over the keys at the last negotiated price. Okay. Now we get to problems that can arise. So, let's say that we have the used car situation and the car dealer says 12, and you say, no, 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 11. And the car dealer is, of course, far away. So you start driving, and then you get to the car dealership, and the car is there that you wanted to buy. And you say, okay, here's the $11,000. And the car dealer says, no, um, I didn't agree to the 11,000. Then there's been no acceptance and you don't have an agreement. If we can make that a little bit harder, so let's say that the car dealer offers at 12 and you're happy with that, and you then start driving to the dealership, and you get there, the car is there, but the car dealer says, no, I decided to sell it to somebody else for 12, even though you told them that you were driving there to pick it up. What happens in that situation? There we get to the concept of a revocation. So, of course, that happens all the time, and the car dealer has the right to revoke an offer. So, as anybody does. So, when you come in and say that you're ready to proceed now, their conduct would be saying, no, that offer is no longer available, which happens very commonly in car dealerships, right? Because they want you to drive in and to get a car, and then when they don't have that one, you're hoping that you'll pick something else, right? That's the whole strategy that maybe isn't such a good deal. But you can revoke an offer, and this gives rise to something called the mailbox rule, where instead of driving there, if the contract was done by mail, the common law predictably had a resolution to the problem of what we just described, which is that if you were buying the car by mail, the car dealer sends you the offer at 12. The mailbox rule says, this is very commonly tested, so you have to memorize this. If you accept the offer at 12 and put it in the mail and it's postmarked, this is the significance of postmarks and why the post office is so keen to put a date stamp on the letter. That means that the offer is accepted when you put it in the mail. Okay, and if you were going by mail, then the car dealer would have to sell it to you. That's why they would only do it on the phone, right? And they don't send offers by email very much, right? Because then you'd have that problem. That is different than the revocation. So the revocation is effective only when it's received, if it's being done by mail. Okay, so then the revocation then, if it was being done by mail, would have to occur before the acceptance is put in the mail. You'd have to actually get a second letter. So the car dealer sends two letters, one that's with the offer, then they get another person buying it, then they send a revocation 2 days later. The offer is valid until the revocation arrives. That's why the post office, one of the reasons, offers certified mails so that they can get a date on when it is done. If there's an offer and an acceptance and the terms are different in any way, or the person says they'll think about it, that's a rejection. That means you do not have a contract. That would be termed a rejection. If either party dies, the contract ends. So, and the offer ends when somebody dies or becomes incapacitated. That means put in a mental hospital or comes under into a coma, anything like that is incapacity. If um, the car dealership makes an offer for 12,000, then there's a hurricane and the car is destroyed, can you be forced to buy the destroyed car? Answer no. The destruction of the property eliminates the contract. We've already talked about the mirror image rule and the mailbox rule. Now, those are two things that you have to memorize. Last question is this. So there's a very interesting example at the beginning of the text of the chapter, and that is that there was a thing called Pepsi points, and this was basically that you would, I remember this promotion because it occurred when I was in high school. And you were supposed to buy Pepsi and then you'd keep like a little tab from the can and you'd get a certain number of points. And then if you drank, 100 gallons of Pepsi, you would get like a t-shirt or something. Well, Pepsi put out commercials on TV offering a Harriet military fighter jet for 7 million Pepsi points. And it was targeted to kids, I guess, so it was why I remember it. And apparently the author does too. And the idea was that you could, if you could get 7 million Pepsi can tops, you could trade them in and get a Harriet jet. The Harriet is the first jet that could vertically take off and land. The United States sold them to England, and England used them in the Falkland War very effectively to destroy the Argentine Air Force, which is why the Falkland Island is still British. In any case, $7 million for a fighter, 7 million points. If you thought of them as $1 a point, $7 million would probably be on the cheap end. I would think a Harriet would be worth 20. In any case, even at that time, a Harrier. So I don't know where they came up with the 7 million Pepsi points, but they put a commercial on national television saying that. And you could either collect the tops to cans or you could purchase the points, and they were 10 cents each. So a kid decided to purchase 7 million points in order to buy the fighter jet that Pepsi had advertised, and did. So he raised $700,000 and sent the money to Pepsi and said, I want to use the 700,000 to buy 7 million Pepsi points, and I want you to deliver the Harrier jet. So basically, he also sent a few Pepsi points in. 15 Pepsi points would be like probably a box top from a 15 pack of Pepsi. And the question was, did we have a unilateral contract there? That's the last question for the lecture. Do you think that that is a unilateral contract? And did the kid sending in the $700,000 to purchase 7 million points at the particular rate constitute a unilateral contract similar to the Lady Gaga situation? Not surprisingly, the holding of the court was that it would not be enforced, saying that they said things like the Harrier jet wasn't in the magazine that said what all the rewards were. You could buy t-shirts and things, but the Harrier jet was just on TV, but every kid in the country had seen it. In any case, they held that it was not a unilateral contract. I don't agree with the holding of that case. I think that they offered a Harrier jet with 7 million Pepsi points. You could purchase the Pepsi points, and they advertised it on TV. And if somebody showed up, as this kid did, he should have got the jet. In any case, but the holding of the case was that he did not, because it wasn't, the details weren't particular enough to cause it to be enforceable. Okay, that is all for today. We'll continue with the next part of the discussion of contracts next week. Thank you.